This is a lecture, a quick review in fact, of the most frequently tested UCC sections. Now I want to be careful not to convey the impression to you that these are the only UCC sections which are tested. I guarantee you that the bar examiners test other UCC sections, but these are the most frequently tested ones, and I encourage you to not only listen to the quick review today, but to actually read those code sections and understand them. Several of these code sections, there are even lectures on that code section, and take a look at those lectures if you would, please. I'll mark those as we go. First of all, 1-203 of the UCC is a section that says good faith, and good faith is required throughout every section. Everything that happens in the UCC is subject to good faith, so they don't need to repeat it every time. That's generally true. However, please note that in Article 2, 2-103, there's a special good faith section for merchants, and it says merchants are required to act in a manner that is honest in fact and that complies with reasonable standards of the trade. Honest in fact and complies with the reasonable standards of the trade. And that's what's in the good faith section. I've not seen a bar exam where you needed to elaborate very much on that, but there have been a few occasions where you could have mentioned it in one sentence, worth something. 2-104. 2-104 defines merchants. Who is a merchant? Now there is an entire lecture. I'm marking the ones that have a lecture with a blue asterisk like this. There's an entire lecture on the subject of who is a merchant, and I encourage you to take a look at that lecture. Essentially, a merchant is one who either deals in goods of the kind or by his or her occupation claims to have knowledge peculiar to these kinds of goods or this type of transaction. And finally, the third way to be a merchant is one who hires an intermediary to act on their behalf. Then that person who hires the intermediary, and if the intermediary by his or her occupation claims to have specialized knowledge, then the party will be treated as a merchant. Please take a look at the lecture on this. It provides the detail that you need. 2-201 subsection 1 is the statute of frauds. Statute of frauds, this is the $500 rule. It provides that a contract for the sale of goods for the price of $500 or more, not more than $500, but $500 or more, and it's the price, not the value of the goods. So if I want to sell you this marker, and we have a contract where you're going to buy this marker from me for $500, forgetting about your insanity for the moment, then it's not the value of the marker, it's the price. If it's $500 or more, it needs to be in writing in order to be enforceable. Secondly, the statute of frauds at 2-201 subsection 1 provides that the writing needs to show at least that the parties intended to contract. The writing must show the quantity. It needs a signature or anything that's acceptable as a replacement for a signature. And mistakes are not fatal. A writing can still satisfy the statute of frauds even if it's got a mistake in it. And if there's a mistake in the quantity, you recall that the contract is enforceable only to the extent that the quantity is in writing. So that if we made an oral contract where I'm going to sell you 100 widgets and the writing said 10 widgets, it's only enforceable as to the 10. That takes care of 2-201 subsection 1, and that brings us to 2-201 subsection 2. This is the part of the statute of frauds that deals with transactions between merchants. And what this essentially does, it says if one merchant sends the other merchant a written confirmation of a contract, and you see it right here. If one merchant sends the other one a written confirmation of the contract, and what is sent is sufficient against the sender, and it was actually received, and was received within a reasonable time, and the person receiving it had reason to know of the contents, and written objection is not given within 10 days of receipt, then it will be treated just as though the receiving merchant signed the contract. Now that's tested a lot. It's tested a lot. Sometimes it's tested in the form of modifications where you and I have a contract and I want to modify the contract. So I call you on the telephone and I say, hey, can we modify? And you say, yeah, we can modify the contract. And so we've agreed on the modification. But if the contract as modified ends up being the sale of, no matter where you came from, if it ends up being the sale of goods for $500 or more, then that modification needs to be in writing. And suppose we didn't put the modification in writing, but we did it over the telephone, then I wrote to you and said, this is to confirm my modification. And you get it and you don't sign it. Then these rules would be applied to decide whether or not you were bound, just as bound as I was. There's a lecture on this. I'll put an asterisk here. There's a full lecture on this subject. It's tested often enough that I made a full lecture out of it, so please take a look at it. 2-207. 2-207 deals with acceptances with proposals, and that's such an important topic and complicated enough that I won't even try to summarize it here, but there is a full lecture on that. Please watch it. It's important. That's tested a lot. 2-209, modifications. 2-209 subsection 1 says no consideration is required for a modification. 2-209 subsection 2 says, and this has never been tested, probably never will, but subsection 2 says if I am a consumer and I go to your used car lot and you're going to sell me a used car and I'm going to pay for it on time and we've got this long contract, that someplace in that contract is going to say this writing is the complete contract and nothing that's said to you by some salesperson or clerk or anybody else is a part of this contract. Well, the UCC requires that I initial that part separately to be sure that was brought to my attention. And that's what this subsection 2 is about. That's never been tested and probably won't. Does not apply if both of us are merchants. But if the customer is a non-merchant and we're using your form, I got to initial that part separately. Thirdly, the statute of frauds rule for modifications, and the statute of frauds rule for modification is that if the contract as modified after the modification has been put into effect ends up being for the sale of goods for the price of $500 or more, then the modification needs to be in writing. That's 2-209 subsection 3. 2-209 subsection 4 says that even if a modification failed, an attempted modification failed because, for example, it needed to be in writing but it wasn't, that attempted modification might serve as a waiver. For example, I have a contract with you to sell you my car for $700 next Monday. And I call you on the phone and I say, and we have it in writing, and I call you on the phone and I say, gee, can I deliver the car on Tuesday instead of Monday? You say, fine, no problem, no problem. Oh, Tuesday's just fine. And now that modification needs to be in writing because we ended up with a contract for the sale of goods for $700 on Tuesday. Okay, and that needs, if we had started there, we would have needed writing. So if we get there any other way, we still need a writing. So that modification needs to be in writing, but it's not. And 2-209 subsection 4 is saying, well, maybe you can treat that modification as a waiver. In other words, you had a right to get the car on Monday, but you waived it. And that does not need to be in writing, so this gets tested often. And finally, waivers are revocable, and unless there's been some reliance on the waiver. That takes care of numbers 4, 5, and 6. There are 11 of these altogether. The seventh one is 2-305. That is the open price term. And that means that these are situations where reasonable price is what is going to be applied. Reasonable price. Those situations are as follows. This is from the code, 2-305, where the parties have said nothing about the price. Reasonable price applies. Where the parties agreed to agree and it failed because they couldn't agree. Reasonable price applies. Where the parties relied on some third-party publication, a price list or some other third-party publication, and the third-party publication doesn't exist anymore, reasonable price will apply. Where the price is to be set by one of the parties, that party has to set it in good faith, not just any old price they want. So that's what 2-305 says. 2-306. 2-306 is about requirements and output contracts. There's an entire lecture on that subject, as the asterisk shows here. Please take a look at it. I won't try to summarize it here. It's too complicated. 2-313, 14, and 15 are the warranties. 2-313 is the implied warranty. Now remember that an implied warranty on a product can be anything that I tell you about the product, or anything that is a tag that's hanging on the product, or something that was advertised about the product, or some pamphlets that were passed out with the product, or a model of the product. All that stuff is considered an express warranty. In fact, the express warranty can even be a name of a product. There was one case on the bar exam where the product was called Bayban, B-A-Y-B-A-N. Now you can figure out what that was about, and yet you can see how that product may very well be viewed, or the name of that product may be viewed as an express warranty, that it will ban babies. And so the express warranty can be almost anything. Implied warranty, that the product is fit for ordinary use. That's the one that said there's a whole lecture. Let me put a mark here. There's a whole lecture on these warranties and products liability area. And finally, 2-315, the implied warranty that the product is fit for a particular purpose. Two 609, which is the 10th one, further assurances. This code section says that under certain circumstances, you can demand that the other side provide you with some further assurances that they're going to perform. And if they don't, it's going to be treated like a repudiation of the contract, which is a breach. And the requirements are here. If a party has reasonable grounds for insecurity that the other side may not perform, they can make a written demand. Please notice that this says written, a written demand for further assurances. And you can, while you're waiting for them to respond to your written demand, you can suspend counter-performance, or your performance, if that's commercially reasonable to do so. The amount of time that they have to respond to your written demand is reasonable time, but less than or equal to 30 days. Reasonable time not to exceed 30 days. And finally, if you do not get the further assurances, that's a repudiation. And that's what 2-609 provides. Then comes 2-615. 2-615 is the commercial impracticability in the UCC. It's not called that, but that's what it is. And what it says is that there are some circumstances where it is commercially impracticable to perform, and your duty to perform will be discharged by commercial impracticability. And when do you have that? Well, right here out of the UCC it says, when you have the occurrence of an event, the non-occurrence of which was presumed by the parties, that may create commercial impracticability if, it's due to things like, we'll come back to that in just a second. Let's come back to here. When does commercial impracticability apply? When you've got the occurrence of an event, the non-occurrence of which was presumed, or if you have to comply with a government order, for example, a ship that's coming into port to deliver some goods, but the government orders them to do something else, and that's going to make the goods late. Well, complying with a government order makes the delivery on time commercially impracticable, and the duty will be discharged, or at least temporarily suspended during the impossibility period. 2-615 points out that a simple increase in cost is not what we're talking about, because that's what's in the risk that you take when you contract with people. We're not talking about ordinary increases in cost, but we are talking about those cases where there may be an increase in cost because of a shortage of supply caused by such things as war, an embargo, local crop failure, an unforeseeable shutdown of a plant or something. This kind of thing. This is not a closed list, but it's that sort of thing where you have an unexpected severe shortage because of that sort of thing, and then your duty to perform becomes discharged by commercial impracticability. And sometimes if the commercial impracticability is only going to last for a short period of time, then you still have the duty to perform, but the time for performance is extended by the amount of time that it was commercially impracticable. Also, of course, it could be that the party on the other end really doesn't want the goods anymore now that they're that late. That is a review of the most tested sections of the UCC. Many of these, as you know, there are full lectures on them. Please listen to the full lectures. Otherwise, please, at the very least, be sure that you read these sections and you understand them, because these are the most heavily tested sections. And that is the end of this lecture.